Hello through to the Help with Debt YouTube channel. My name is Steve Thatcher. Some of you may have seen some of my videos before. Today I'm going to be giving a brief explanation of bankruptcy and income payments. Now, if you go bankrupt in England and Wales, one of the aspects of your life that the official receiver will look at is whether you have any excess income left after you've spent the money coming into the house. If you do, then the OR can ask you to pay that to him as an income payments agreement. Now, if the agreement cannot be reached, the OR has the right to take the matter before a judge, and if the judge agrees, he will make an income payments order. The way that the OR has come to a determination about the amount of money available to him has just changed from the 1st of December 2011. The changes are not retrospective, so they will not affect any income payments orders, that's IPOs or IPAs already in place. Prior to the 1st of December, the first £100 of any surplus income that a bankrupt had in his estate would be exempt from an IPA. Any money over and above this would then be taken on a sliding scale of 50 to 70%. With the changes, only the first £20 will be discounted, and after that 100% of any surplus income will be taken towards the IPA or IPO. This is quite a significant change. This meant that prior to the 1st of December, if there was a surplus of £400, not likely I grant you, as you could probably afford your debts at this level, then an IPA would be put in place for £260. Under this new system, if there were to be a similar surplus, then the IPA would be in place for £380. I suspect that this has been done for two reasons. Firstly, the insolvency service has to be as self-funding as possible. In the past, they have been able to rely on property realisations to provide assets from which they could take their fees. Now, with many properties having no equity, this is not bringing in the needed revenue. Changes to the way that IPAs are calculated could redress this. Secondly, the sums demanded from debtors in an IVA leave no room for surplus income, and so this new regime brings the two systems nearer into line. Whilst the changes may seem draconian, it must be remembered that the IPA lasts only 3 years, and not 5 or 6 under an IVA, and allowances that you can offset against your income in a bankruptcy are much more generous. You can, for example, set aside money for a holiday under a bankruptcy, but you cannot in an IVA. So, if you need further advice and assistance on the effects of the IPA changes, please call me 0808 160 5577, and my name is Steve Thatcher. Thank you.